The Eastern Caribbean Supreme Court delivered a judgment decriminalizing buggery, or otherwise referred to as certain consensual sexual conduct between adults 18 years and older in private in St. Kitts and Nevis. According to the Collins English Dictionary, buggery is defined as anal intercourse between a man and another man or woman. The judgment, delivered by His Lordship Mr. Justice Trevor Ward, QC, arose from a constitutional motion filed in January 2021 by Jamal Jeffers, a citizen of the Federation, and the St. Kitts and Nevis Alliance for Equality, Inc., SCANAFE, a community-based non-profit organization founded by Tinetta McCoy. The Attorney General was the named defendant, as is the requirement in constitutional motions of this nature. Mr. Jeffers and SCANAFE sought declarations that Sections 56 and 57 of the Offences Against the Persons Act, Cap 4.21 of the laws of St. Kitts and Nevis, contravened Sections 3, 7, 12, and 15 of the Constitution, and as such were null, void, and of no force and effect to the extent that they applied to the consensual intercourse in private between persons 16 years of age and more. Prior to the judgment, it was a criminal offense in St. Kitts and Nevis to commit, quote, the abominable crime of buggery and the related offences of assault with intent to commit buggery and indecent assault upon any male person. These crimes were punishable by imprisonment of a period not exceeding 10 years with or without hard labour. According to a press release from the Ministry of Justice, in the judgment, the court declared that buggery and related crimes referenced in Sections 56 and 57 of the Offences Against the Person Act contravene Sections 3 and 12 of the Constitution of the Federation of St. Christopher and Nevis, namely the right to protection of personal privacy and the right to freedom of expression. Therefore, buggery in St. Kitts and Nevis is no longer a crime once it involves acts constituting consensual sexual conduct in private between adults. A press release from the St. Kitts and Nevis Information Service said that the Cabinet of the Government of St. Kitts and Nevis was on Monday made aware of the decision. The trial took place on June 10, 2022. Meanwhile, the organization representing members of the LBGTQ+ community in the Eastern Caribbean, the Eastern Caribbean Alliance for Diversity and Equality, ECADE, and the St. Kitts Nevis Alliance for Equality, SCANAFE, welcomed the decision of the Supreme Court. In a press release, both organizations said, in a second case of historic precedent, the Eastern Caribbean Supreme Court in the Federation of St. Christopher and Nevis has affirmed the constitutional rights of LBGTQ+ citizens by striking down the country's buggery law. The release continued in declaring void Sections 56 and 57 of the Offences Against the Person Act. The High Court of Justice in St. Kitts and Nevis affirms the laws that criminalize consensual private sexual acts between adults to be unconstitutional. ECADE said it remains committed to challenging, quote, the harmful beliefs that underpin these laws and create an atmosphere where stigma and discrimination against individuals perceived to be LGBTQ+ are acceptable, end quote. The full text of the press release can be found on the SK Newsline website at www.sknewsline.com under the press releases section. SK Newsline will continue to monitor this developing story. I'm Andre Huey for SKN Newsline.